Last week, the U.S. Supreme Court issued an opinion on OSHA's emergency temporary standard relating to COVID-19. This will stand as one of the monuments of occupational safety and health law, and we're going to discuss the opinion, what it meant, the reasoning that the justices used in arriving at their opinion, and what employers should expect next and what they can do in light of the Supreme Court decision on this, the January 19, 2022 episode of the OSHA 3030. Welcome to the OSHA 3030. I'm Manesh Rath. I am a partner at the law firm Keller and Heckman right here in Washington, D.C. And I'm an attorney who engages in the practice of occupational safety and health law, representing management. And I'm fortunate because I'm joined today on this episode of the OSHA 3030 by my friend and colleague, Taylor Johnson. Taylor, thank you for joining us on the OSHA 3030.
Pleasure as always, Manesh.
Well, Taylor, we've got a great topic today, a monumental decision. And I think that we ought to start by saying that this begins as January of 2022. It begins, probably, I think that's about 7, 8, 9 years. It's our 9th calendar year, or 8 years total of doing the OSHA 3030. And all of our prior episodes of the OSHA 3030 have been libraried on our website, khlaw.com. So, and many of them are still as relevant today as they were when we created them. For the past many years, we've been doing this also as a podcast. So for those of you unaware, please subscribe to the podcast and remember to rate or like it when you get it. With that said, Taylor Johnson, why don't we get into talking about what we'll talk about today?
Absolutely. So, we've got a really informative program lined up today. First, we're going to discuss the historical precedent for OSHA emergency temporary standards. Then we will review the timeline of the COVID ETS, how we got to this point. Next, you and I will provide an analysis of the Supreme Court's ruling. We will provide an update on state plan states. And most importantly, we'll discuss what happens next and what the employer community should do moving forward. And finally, at the conclusion of our program, we're going to go off the record, turn off the recordings, and answer some pre-submitted questions from our audience. And we have some great questions today.
That's right. We've been doing that for about 1 year now, this off the record portion. So this portion is recorded so that we can republish it as a podcast, but as well, we post it on as video with slides and the audio on our website, and it's housed through YouTube. And so you can check it out there as well. But the off the record portion is where we turn off all the recordings, and that's just for you, the live audience that attends and joins us on the scheduled date. So thank you for participating in the live audience. And we send out an email a few days early and ask you if you have any pre-submitted questions that you'd like us to review in advance. And then we populate the off the record section with those questions. But you may also use the question and answer section of the Zoom meeting if you prefer. And we'll try and get to all of those. Those go to the back of the line, and some of them, if they're longer, they're harder to read, we may be able to answer them offline as well in order to make sure everyone's questions get answered, hopefully. So with that said, you said, Taylor, that we're going to start off talking about the precedent for the use of emergency temporary standards. I think that is a good place to start. The emergency temporary standard is a feature of the Occupational Safety and Health Act. So it's in the act that it allows the agency to go through creating a rule relating to safety and health in the workplace, provided that it goes through notice and comment rulemaking, what I'll call traditional rulemaking or notice and comment rulemaking. But there's also a provision that allows the agency, in the context of an emergency, to skip the notice and comment rulemaking for the time being and go straight to issuing an emergency temporary standard. Now, that's sort of a trade-off, the trade-off being that they may only issue this emergency temporary standard for 180 days. And during that 180 days, they may do so only while promulgating the traditional notice and comment rulemaking. They must use that 180 days for traditional rulemaking purposes to implement a permanent rule in lieu of the temporary rule once the 180 days has transpired. There have only been a number of circumstances, a limited number of circumstances where the agency has used this extraordinary statutory power. And we've shown them here starting in 1971, shortly after the agency was created in the as a feature of the Act, and going through 1983 with the asbestos emergency temporary standard. Almost all of them have been challenged, and almost all of those, the challenge has been successful on one basis or another. Indeed, the Supreme Court noted in its opinion last week that there's only been one emergency temporary standard in all of these almost 50 years of the creation of the agency and the act, where an emergency temporary standard went unchallenged and survived in its entirety. And so that's an exceptional fact historically, which illuminated the Supreme Court justice's decision and how it viewed the use of this extraordinary statutory power.
That's right, Manesh. And the day after the ETS was published in the Federal Register, just to give sort of a sense of the timeline here, the Fifth Circuit Court of Appeals granted a temporary stay, putting implementation of the ETS essentially on hold. That stay was then lifted by the Sixth Circuit Court of Appeals on December 17th. And from there, Justice Kavanaugh granted review of the Sixth Circuit's decision. Justice Kavanaugh essentially stated that he was single-handedly granting review, but that the review would be handled after a hearing by the entire Supreme Court. That hearing took place on January 7th, as you can see here. And on January 13th, the Supreme Court opinion in National Federation of Independent Business versus OSHA and Ohio versus OSHA granted two consolidated applications for a stay of the Sixth Circuit decision. And Manesh, there was actually three opinions issued in relation to these two cases.
Well, that's right. And to point out something that you mentioned, Taylor, that Justice Kavanaugh single-handedly granted review, that is a unique feature in the Supreme Court procedural rules where an emergency hearing can be granted or emergency review can be granted, and that's expedited. And that can be done by any one justice. So that was within conformance of the rules. What was unusual was that he then said that this would be done after a hearing in front of the entire Supreme Court. So as you say, there were three opinions, and that hearing was an interesting one. I sat in on the entire hearing. I got to hear the justices' questions of all of the attorneys for the multiple parties, including the Solicitor General for the Department of Labor. And I think that the nature of the questions was at least as informative as the answers that the participants provided. Ultimately, as you mentioned last week, the Supreme Court issued an opinion in the form of three separate opinions. One was the per curiam decision, where the majority issued their decision saying that, stating their belief that the party challenging the rule and supporting the stay in the Sixth Circuit was likely to prevail on the underlying merits of whether or not OSHA has the statutory power to promulgate this particular rule. And the Supreme Court therefore granted in the per curiam decision the applicant's petition for a stay pending judicial review on the merits by the Sixth Circuit.
There was also a concurring opinion issued by Justice Gorsuch, who was joined by Justices Thomas and Alito.
So that would suggest that the participants in the per curiam decision, in addition to being joined by Justices Gorsuch, Thomas, and Alito, would have included Chief Justice Roberts, and that I think is an important feature of. But we don't know who authored the per curiam decision. Then there was a dissenting opinion authored by Justices Breyer, Sotomayor, and Justice Kagan. And in that dissenting opinion, the dissenting justices identified their bases for disagreeing with the majority opinion. So it was a 6-3 majority.
That's right. And Manesh, as you mentioned, in the end, the court granted the applications for a stay, holding that the ETS was essentially tantamount to a public health mandate, which would exceed OSHA's statutory power.
So this is interesting. The justices, now at this point, let's talk about the majority opinion, which was at least included Justices Roberts, Kavanaugh, Justice Barrett, as well as Justices Gorsuch, Alito, and Thomas. The majority started out by identifying the threshold elements by which the Occupational Safety and Health Administration has to meet a standard for allowing them to use the emergency temporary standard powers granted it by the statute.
That's right. The first being that employees are exposed to a grave danger in the workplace, of course.
That's right. And the second being that the emergency temporary standard is necessary to protect employees from such danger.
Right. And the court states that although COVID-19 is a risk that occurs in many workplaces, the point that they wanted to draw is that it's not an occupational hazard in most workplaces.
This is a critical point that the majority opinion stressed in its decision. It stated that it had great doubt that the Occupational Safety and Health Administration was given the authority by Congress to regulate the kind of hazard that was not uniquely workplace oriented in nature, or didn't originate in the workplace, or wasn't by some measure increased or exacerbated in the workplace setting, that Congress did not intend to give the agency the authority to regulate hazards that are essentially prevalent in all aspects of society, but also happen to be manifest in the workplace as well. Noting that to do so would transfer or connote powers to the agency more akin to a public health agency rather than an occupational safety and health agency. That's an interesting opinion, and it was prevalent in their questions. When I listened to the hearing, I came to the conclusion that the questions were, by many of the justices, expressing grave doubt that this was originally Congress's intent. And the response by the parties, varying based on the arguments they were advancing, was that, of course, this was something that Congress had promulgated 50 years ago. But the Department of Labor said it was patent in the congressional intent by the fact that there was an emergency temporary standard provision. But of course, there wouldn't be anything specific in congressional expression of intent about this. They couldn't have foreseen it. So then there's the dissenting opinion.
That's right. And, as you mentioned, this was issued by Justices Sotomayor, Kagan, and Breyer. Essentially stated, first off, that COVID-19 does pose a grave danger, particularly to workers. So this, in contrast with the main opinion in the case. And for support of this grave danger argument, the dissenting opinion pointed out that, as of the time of the rule, there were over 725,000 Americans dead, and millions more had been hospitalized due to COVID-19. The dissent states that OSHA had, in fact, in the past, regulated risks that originate both inside and outside the workplace, and also pointed out that in the American Rescue Plan Act, Congress did, in fact, state its clear intent for OSHA to carry out COVID-19 worker-related protection activities in the work environments of all kind. And the dissent states that the Supreme Court, in its main opinion, was elevating the judiciary over the regulatory agency, OSHA in this case, charged with workplace safety, and that instead it must balance the result of a stay versus what would happen if a stay was lifted.
That last point, Taylor, is one of the elements of evaluating a injunctive relief, is a balancing of public interests. And the dissenting justices noted that there is a significant public interest in making sure that the rule is put into effect immediately. First of all, they noted the lives that the Department of Labor calculated would be saved. And second, they said that, if a larger fraction of the workplace was vaccinated, then you would see attendance go up and businesses would keep running. And so they were skeptical of the challengers to the rule, their assertion that this was an incredibly expensive rule to implement. I mean, I think that it's safe to say that the argument was that it was an unbearably large burden to engage in the administration of the requirements, as well as the procurement of tests, et cetera. So for those for whom the standard required by force of an accommodation that the employer pay. So they engaged in that analysis, and I think that when you look at these two opinions, Taylor, you see that they're looking at different parts. They're emphasizing different parts of the analysis. The dissenting opinion goes straight to the threshold questions of whether or not the agency can use this emergency temporary standard power as a question of whether or not there's a grave danger that's present and whether or not this rule is necessary. And the majority justices, the justices aligned in the majority, focused on the step prior to that in their analysis, which is if you're going to accept that there is a grave danger and that the requirements of this standard will have a mitigating effect, the prior question to ask, the threshold question to ask is, does OSHA have the power to implement those requirements? Interestingly, the concurring opinion, which was authored by Justice Gorsuch, he stated that when it comes to a major question, and this is an established part of Supreme Court doctrine, that when it comes to a major question, one that has profound, widespread societal impact, the Supreme Court must look more carefully at whether or not the regulatory agency is fulfilling a clear and unambiguous congressional intent, expression of intent. And so at least in his concurring opinion, he was most focused on that question, which was, even if you agree that OSHA has emergency temporary standard powers and that there is a grave danger that's present, when you talk about requirements that are this broad sweeping, he would like to see clear, unambiguous expression of congressional intent. And he opined that he did not see that. And as you pointed out, Taylor, the Department of Labor's attorney argued that there was an expression, clear expression of congressional intent. And one example she cited too was the American Rescue Plan Act. So compelling arguments on both sides. Well, what does this mean now that the Supreme Court has weighed in on this and has agreed that there should be a stay on the emergency temporary standard until such time as it's heard on the merits? Well, for one thing, in the meantime, there have been a number of state plans that have promulgated near identical rules under their requirements to promulgate a plan that is at least a standard that is at least as effective as the federal standard. And in the case of an emergency standard, they have to do so within 30 days, I believe. So that's expired, and several states did so, fulfilled their state plan duty to do so. Illinois and Minnesota jump to mind. Of course, there were other state plans that had already issued their own standards, which were significantly different than the federal standard. Virginia, Michigan, California are good examples. So what becomes of those standards that were promulgated in light of or in the wake of the federal emergency temporary standard? Well, two of them, Illinois and Minnesota, have published statements. Their occupational safety and health agencies have published statements saying that they were suspending their emergency temporary standard in light of the Supreme Court decision. And so if you have establishments in those states, you can now rest easy that the state plan state is also viewing itself as under the stay, at least based on the principles expressed by the Supreme Court.
So we covered what's next in terms of state plan states. Now, from a procedural perspective, what happens now is that the case goes back to the Sixth Circuit for a ruling on the merits. The stay remains in place during Sixth Circuit review, as well as any second appeal to the Supreme Court. The Supreme Court ruling that plaintiffs are likely to be successful on the merits is influential, but not binding. So there's not a 100% certainty that the plaintiffs challenging the ETS will be successful in the Sixth Circuit. But that being said, it's certainly possible that OSHA withdraws the ETS during the Sixth Circuit's review, which would essentially moot the case. And also, important to point out here in terms of the timeline, that OSHA has until May 5th, 2022 to implement a final rule to replace the ETS. So that's certainly a deadline that the Sixth Circuit will have in mind when making its decision.
Well, it's interesting. You're right, Taylor, because the Sixth Circuit may have until several weeks after that to hold a hearing and conduct and issue an opinion.
Right.
And if that's so, then this may be mooted by force of the Sixth Circuit opinion, or by the permanent rule that OSHA might establish. And there's any number of ways this could be mooted. OSHA could withdraw its emergency temporary standard, and so the Sixth Circuit's evaluation of the merits of this case are, I think, of great interest, and the timing of it will be of great interest, and could play a major. The timing itself could play a major role in how this turns out. So what's next? Well, as I mentioned, the standard for the emergency temporary standard, issuing an emergency temporary standard, calls for the agency to promulgate traditional rulemaking during that 180 days that the emergency temporary standard is in effect, and that it publish a permanent standard in its wake. And the comment process was opened up with the publication of the emergency temporary standard. Indeed, the comment process, the deadline for filing comments is today, I believe. And so this is an important deadline because OSHA still has an opportunity to issue a permanent standard, and on a different basis than the emergency temporary standard. The analysis of whether or not there's a plain danger, the grave risk, analysis of whether or not this standard is absolutely necessary to have a reductive effect on the alleged hazard, they don't apply if there was traditional rulemaking. So what will apply is whether or not OSHA went through the proper rulemaking effort and considered the substantial evidence presented before it. The Supreme Court anticipated this in its opinion, in the majority opinion, and stated that it's possible for OSHA to issue a standard relating to COVID-19 risk management. And it provided that the agency issues a standard that's targeted to the risk it's addressing, then such regulatory activity would be plainly permissible. And I think that's interesting. I think that as I read that, I think that it can be cut two different ways, at least. One, by task or by industry. For example, we know that super crowded facilities, workplaces like the meatpacking industry or nursing homes, any kind of group housing would qualify as having an elevated workplace associated risk. Healthcare is a good example as well, obviously. And I note that on the same day, they heard a hearing right after this hearing relating to the healthcare related standard. And that was upheld by the Supreme Court. But the other way to do this would be to make sure that the requirements are targeted to the risk and that they are targeted to the workplace. So for example, where vaccination was a requirement that the Supreme Court cast doubt was within the agency's power because it affected all of society, it affected people at home as well as when they were at work. Mask usage would not. Mask usage could be targeted to just work. And the same goes for distancing practices, the use of plastic barriers where possible, hand washing as a required regimen. These could be implemented at the workplace without having any effect on a person's personal life. And that seems to me to be more narrowly tailored. And so it's theoretically possible that the agency could fashion a final rule that is mindful of the principles established by the Supreme Court and at the same time could theoretically survive another challenge and go forward with enforcing. So that's what we see as a possibility for notice and comment rulemaking.
That's right, Manesh. And in terms of what's next for other potential OSHA actions, we got some indication of what's coming down the road on January 13th when Secretary Walsh issued a statement. He said that OSHA will be evaluating all options to ensure workers are protected from the COVID-19 virus. Just some of the options listed in his statement were the COVID-19 National Emphasis Program. There's also the general duty clause as a potential avenue for OSHA to use. However, with respect to the general duty clause, we wanted to point out that as the Supreme Court essentially said that this is, this being COVID-19 is not a workplace hazard, then under the general duty clause, it would not be a generally recognized hazard either. A generally recognized hazard being one of the elements of a general duty clause violation. So that's something that we'll keep an eye on moving forward and see how any general duty clause enforcement cases with respect to COVID-19 will play out. And finally, as the agency looks to protect workers from COVID-19 using existing standards, such as the respiratory standard, for example, we wanted to note the new, maximum penalties for willful repeat violations, which is $145,000, and the new maximum penalty for a serious or other than serious violation, which is $14,502. So something, Manesh, to keep in mind moving forward.
Yeah, that's right, Taylor. That represents the single largest inflation-based increase in the maximum citation penalty amounts since the inflation-based system was implemented a few years ago. It's an easily 6% increase over the prior maximum for citation penalty amounts. So, Taylor, let's talk about what employers could do in light of this monumental decision. Uh, I'd say, first of all, today's the deadline. I hope that employers are working with their industry groups to prepare and submit comments. I think one of the comments that is fair play is that this standard should not be promulgated in light of the Supreme Court decision. But if the agency decides to go forward with one, it should be based on a particularized inquiry by each employer based on their tasks that are present in their workplace and the risks associated specifically with those tasks, not an extant or pervasive societal risk of COVID or people bringing societal or community-based transmission into the workplace, but based on the specifics of each task at the workplace. And that on that basis, the employer should employ its own discretion to deploy the most appropriate mitigative techniques that are appropriate and calculated to reasonably calculated to have a reductive effect. Things like mask usage or distancing or barriers, and exceptions where the tasks don't call for any of these, like outdoor work, sparse density of workers or people associated with the worker. Those kinds of particularized inquiries should be the kind of features that the employer should be given discretion to determine on their own based on their own knowledge of their workplace. So I think that that's the kind of element that you might consider including in comments to the agency.
Absolutely. Also monitoring for state regulations in state plan states. As we mentioned earlier, there's certainly a few states, Illinois, for example, where they're staying their implementation of sort of their own ETS that would mirror the federal standard, but that doesn't mean that something else might not happen down the road. So certainly, Manesh, important to make sure that we're monitoring state regulations in those state plan states.
Yeah, Taylor, that's right. In fact, quite the opposite. President Biden, after the Supreme Court issued his decision, said that it now devolves to the states and to private employers to implement requirements that will have a mitigative effect on the transmission of COVID. And so based on the president's own statement, you can expect that some states will take up that call and promulgate some kind of rule, perhaps mindful of the limitations expressed by the Supreme Court. But nevertheless, you may see new versions of standards, either emergency temporary standards or permanent standards, being tried out at the state level. So I think the next thing I think that employers can do, Taylor, is to continue to develop policies that are mindful of guidance issued by the Centers for Disease Control and by the Occupational Safety and Health Administration. So it's important to monitor those agencies for their guidance documents, as well as deploy those guidance elements that are applicable in your workplace and that make sense in your workplace as you deem fit, where those changes in guidance dictate changes in your own current practices.
Absolutely, Manesh. And one of the other things I think that employers could do as well is tailor protections to the specific circumstances of the workplace. So is it crowded, for example, on a meat packing floor, for example, would be one of the things that we would encourage employers to look at the specific, specifically how COVID-19 can impact their workplace, and then generate protections that respond to those circumstances.
Yeah, that's a good point, Taylor. That mirrors what I was saying that the comments should look like to the agency, is to allow employers to make a particularized hazard assessment based on their own job site and the particularities of it and the tasks being performed, and then to tailor their protections accordingly. I think that should be in the comments. And you're right, Taylor, that should be what employers should begin doing, or probably have already been doing for quite some time. The next thing I'd say is that employers should document the source. Every time they implement a policy or practice, they should document the source for that policy or practice. So if it came from a CDC guidance or it came from an Occupational Safety and Health Administration guidance, that should be documented to support the employer in why it arrived at that decision. And I think that kind of documentation will stand to protect employers, hopefully a little bit better, if they come across the kind of lawsuits that we've covered in the OSHA 3030, the Amazon warehouse on Staten Island, for example.
That's right. And just going off of that point in terms of, protection from lawsuits and documentation, employers should also develop written safety programs for COVID-19 protection measures, have a written program in place that documents all of the different protection measures that the employer is implementing.
Well, Taylor, that was exactly 30 minutes. That's why we call it the OSHA 3030. And you got the last word on this OSHA 3030. Thank you, Taylor, for joining me. Thank you all for participating. Don't forget, we're sticking around for an off-the-record chat with just the live participants. Remember that you can catch this episode in a day or so and all of our prior episodes on our website, khlaw.com/OSHA 3030. I should also point out that we are all on LinkedIn, and we will rebroadcast this as a podcast on your favorite podcast platform. And this will also be available as slides and audio on our website, as well as through YouTube. You can just go straight to YouTube and Google it up, search it up. And finally, I'd say that the next episode that we're going to all get together again for the OSHA 3030 will be scheduled for February 16th at 1 p.m. Eastern, always on a Wednesday, always at 1 p.m. Eastern. And so please spread the good word when you get this invitation to the folks in your organization's Office of In-House Counsel, or to safety and health professionals in your organization, or at other organizations. Your referrals are the lifeblood of the future of the program. We've been doing this for over 8 years. We'd like to do this for 8 more, but it requires, and we're counting on your support in spreading the good word. So be a supporter and a promoter of the program. When you get this email, just forward it along. We have sister programs for those organizations that are responsible for compliance with TSCA and REACH and FIFRA. We have programs on those subjects as well. So please pass the good word on about the TSCA 3030 and the REACH 3030, Wednesday, February 9th at 1 and 1:35 respectively, and for the FIFRA 3030 as well. So thank you again. Thank you, Taylor Johnson, for joining me on this OSHA 3030. Thank you to all of the participants in the OSHA 3030 this month. And if you have any questions that we haven't addressed and you want to use the question and answer feature, stick around. Otherwise, shoot us an email or give us a call. I love chatting about OSHA law and don't mind the emails or calls, especially if it's a quick question I can answer off the top of my head and it's a chance to connect. So with that said, we are going to go off the record, and thank you all. And we'll look forward to seeing you next month. Until then, stay safe.